2024 Scmr 46. The case of 2024 Scmr 46 discusses the scope of judicial review in matters relating to the policies, discipline and other academic affairs of educational institutions. The Supreme Court of Pakistan held that courts are required to exercise utmost restraint in such matters and will only intervene if the regulations can be clearly shown to contravene the law or to be shockingly unreasonable or perverse. The court also explained that educational institutions have the exclusive domain to formulate policies and eligibility criteria, and that courts are not equipped to deal with academic matters. The case involved medical students who were unable to complete their studies due to failing exams after 4 attempts. The students argued that the regulations were unfair and that they should be allowed to complete their degrees on compassionate grounds. However, the court ruled that the regulations were valid and that the students were not eligible to continue their studies. The court's decision was based on the following principles. Courts are required to exercise utmost restraint in matters relating to the policies, discipline and other academic affairs of educational institutions. Refusing to interfere is a rule and deviation therefrom is an exception which can only be justified on the basis of clear and undisputed violation of the law. The reluctance of the courts to interfere with academic affairs is based on the foundational principle that the academicians and educational institutions are the best judges because formulating policies and eligibility criteria falls within their exclusive domain. The standards prescribed and set out in the regulations relating to academic bodies, determination of eligibility to pursue studies, and other related policies are generally not open to judicial review unless they can be clearly shown to contravene the law or to be shockingly unreasonable or perverse. Every citizen is unquestionably entitled and enjoys a right to choose the pursuit of a profession or trade, but such a right is not absolute. The regulating authority may set minimum standards in the context of exercising the right in order to safeguard the interests and welfare of the public. In conclusion, the case of 2024 Scmr 46 highlights the limited scope of judicial review in matters relating to the academic affairs of educational institutions. Courts will only intervene if the regulations are clearly unlawful or unreasonable.